5 seconds to go. Start. There cannot be any disagreement with the submission made by Mr. Luthra for the accused that the expression sexual intent having not been explained in section 7, it cannot be confined to any predetermined format or structure, and that it would be a question of fact. However, the submission of Mr. Luthra that the expression physical contact used in section 7 has to be construed as skin to skin contact cannot be accepted as per the rule of construction contained in the maxim "Atres magis velet quam periet," the construction of a rule should give effect to the rule rather than destroying it. Any narrow and pedantic interpretation of the provision which would defeat the object of the provision cannot be accepted. It is also needless to say that where the intention of the legislature cannot be given effect to, the courts would accept the bolder construction for the purpose of bringing about an effective result, restricting the interpretation of the words touch or physical contact to skin contact would not only be a narrow and pedantic interpretation of the provision contained in section 7 of the POCSO Act, but it would lead to an absurd interpretation of the said provision. Skin to skin contact for constituting an offence of sexual assault could not have been intended or contemplated by the legislature. The very object of enacting the POCSO Act is to protect the children from sexual abuse, and if such a narrow interpretation is accepted, it would lead to a very detrimental situation, frustrating the very object of the Act, inasmuch as in that case touching the sexual or non-sexual parts of the body of a child with gloves, condoms, sheets, or with cloth, though done with sexual intent, would not amount to an offence of sexual assault under section 7 of the POCSO Act. The most important ingredient for constituting the offence of sexual assault under section 7 of the Act is the sexual intent and not the skin to skin contact with the child. At this juncture, it may also be beneficial to refer to the observations made by the foreign courts in the judgments cited by Ms. Geeta Luthra, wherein the said courts, while interpreting analogous provisions as prevalent in such countries, have held that skin to skin contact is not required to constitute an offence of sexual assault. It is not the presence or lack of intervening material which should be focused upon, but whether the contact made through the material comes within the defined prescribed for a particular statute has to be seen. Of course, the judgments of the said courts proceed on the interpretation arising out of the terms defined in the provisions contained in the concerned legislations and are not pari materia to the language of section 7 of the POCSO Act. Nonetheless, they would be relevant for the purpose of interpreting the expression touch and sexual assault. The Court of Appeal, while interpreting the word touching contained in Section 3 of the Sexual Offences Act 2003 as in force in UK, observed that the touching of clothing would constitute touching for the purpose of said Section 3. Similarly, the Court of Appeals of Iowa held that a lack of skin to skin contact alone does not, as a matter of law, put the defendant's conduct outside the definition of sex act or sexual activity, which has been defined in section 702.17 of Iowa Code. The act of touching any sexual part of the body of a child with sexual intent or any other act involving physical contact with sexual intent could not be trivialized or held insignificant or peripheral so as to exclude such act from the purview of sexual assault under section 7 as held by this court in case of Balaram Kumawat versus Union of India Supra. The law would have to be interpreted having regard to the subject matter of the offence and to the object of the law it seeks to achieve. The purpose of the law cannot be to allow the offender to sneak out of the meshes of law. It may also be pertinent to note that, having regard to the seriousness of the offences under the POCSO Act, the legislature has incorporated certain statutory presumptions. Section 29 permits the special court to presume when a person is prosecuted for committing or abetting or attempting to commit any offence under section 357 and section 9 of the Act that such person has committed or abetted or attempted to commit the offence as the case may be unless the contrary is proved. Similarly, section 30 thereof permits the special court to presume for any offence under the Act which requires a culpable mental state on the part of the accused the existence of such mental state. Stop.